Here's the thing. I have, well, now 29 minutes to actually go through the Fourth Amendment. So, right? So buckle up. It's going to be a ride. And then at the end of it, I've got something we really need to have a conversation about regarding a case that came out last year, specifically a 3-2 decision of State versus Spears. And it's going to be a good one. So without further ado, let's get rolling right into it. General overview of search and seizure. By the way, I don't care if you're Gen X, Z, Boomer, whatever. This applies to all of us. So sit back and enjoy. All these materials are available to you, so don't feel compelled to write anything down if you don't want to. If you want to, that's cool too, but we're going to go fast. So here we go. What is this all based on? Fourth Amendment law. We all know and love and cherish the Fourth Amendment. We do. Why? We got a right to be secure in our things, right? And in our person. Meaning what? Right to people to be secured in persons, houses, papers, effects, etc. We've all read this before, okay? But it's one thing to actually just read the clause itself. What we really want to focus on is how is it really divided legally speaking, right? Two parts. One, the reasonableness clause. What does it seek to prohibit, right? What's reasonable? And two, the warrant clause. It's all about warrants and specifically the particularity requirement, okay? So let's talk about the reasonableness clause. Who is covered? People, all right? The people, right? We the people. Yeah, it's us, okay? Great. What? So it's not dogs, not cats. Like, oh no, you know, this lady died and left all her money to the cat. No, it doesn't cover the cat, right? What is covered? Persons, houses, papers, and effects. That's a lot of stuff, which by the way, as time has gone on, things have become an electronic world in which we live. I love the Carpenter case that came out a little while ago. Yes, it's the Supreme Court recognizing this does protect electronic things as well. I love it. All right, the nature of the protection though, this is also something you really got to focus on. Is it unreasonable? Protects us against unreasonable searches and seizures, right? We're going to talk a minute about seizures when it comes to our case update as well. So each one of these things we're actually going to touch on has a mountain of case law beneath it, okay? So we're just literally going to be skipping across mountaintops throughout our whole conversation today, all right? Each issue has sub-issue. Each sub-issue has sub-issues upon sub-issues. We know this, okay? So who are the people, right? Well, that's easy. There's a case on it. Of course, it's a class of persons who are a part of a national community or who have otherwise developed sufficient connections with this country to be. Do you have to be a United States citizen for this to apply? That's what it boils down to. The answer is no. All right, this applies to everybody here, Jack. Everybody. Mr. Stevens, your client's an illegal alien. And no, they don't mean Pluto. My answer is, and? So what? All right, yes, he does have rights. When you step across the border, yes, your Fourth Amendment rights are there, okay? Now, is there anything that is not a person, house? And again, that's what it's really boiling down to. What would be outside of that realm? Because there are cases touching upon that as well. Next, what is a search and or seizure under the Fourth Amendment? Two big cases that we all know, we all cherish. Terry versus Ohio. I freaking hate Terry as well. It's right. Well, actually, let me back it up. I hate the war on drugs, and that goes back to none other than Tricky Dick Nixon, right? So if we really want to point the finger at somebody who became a wrecking ball in the Fourth Amendment, blame the easiest guy to blame for everything. Blame Richard Nixon, okay? And then finally, U.S. versus Mendenhall, which is going to actually put focus on the standard we need to apply. And also what makes it unreasonable. The warrant clause, let's talk about that. Because there are some good cases that within the last 5 years have come out of our own state Supreme Court that have really highlighted that this still has teeth to push back on the government, okay? If they're going to get a warrant, they have to have probable cause supported by oath or affirmation, okay? What form? Yep, it's got to have it. You got to be a warrant, and it has to give particularity describing the place to be searched and the person or things to be seized. All right, I love this because when they get that warrant and they go there and they say, "Hey, all this stuff, you know, in this little path over here, you know, we're going to stop all the people running up and down that path too." No, you can't. I'm really sorry about your luck, right? Or hey, we're going to go back in here because you know this is a big barbecue where the only thing they're cooking is crack. Well, great. Did you get your warrant? And if so, what's the particularity requirement? You're outside of those bounds, and guess what? It's out. All right. I love it. Sub-issues of the warrant clause. All right. What constitutes probable cause? This is a tango we all do all of the time. Honest to God, the most common place I have this conversation with cops and with judges is actually prelim hearings. All right. Who really likes going to the preliminary hearings? All right. We're nerds, and that's cool. Here's why. Okay. It's the one time, it's almost like a free shot to be able to use it the way they never want you to use it, all right? It's almost like I get to have a free deposition for 10 to 15 minutes with this cop, all right? Love it. All right, are they gonna give me, I'm typically gonna win the argument in front of the judge? No, right? I know that already. That's not the point. The point is I'm gonna learn a lot more about that case with the cop under oath that's far beyond just the four corners of that report, okay? Now, I got to keep everything relevant to what he already put in. That's not a problem. That's easy for us as attorneys, right? Do it. You put the screws to him. All right, well, what was your probable cause, officer? It's one of the few times I'm actually going to ask a whole bunch of open-ended questions to the cop, right? And then if I really want to get nasty, I'll start, nailing with some really specific questions. So what am I doing? I'm making a record, basically a recording, and then I'm going to get the recording from the court afterwards, and I'm going to use that sucker when I push in the prosecutor, or later on get a transcript of it when I push him in court on cross-examination when it really counts, all right? Do it, because what they'll say in prelim hearing is often very different of what they want to pawn off in circuit court. Pin them down and pin them down early, okay? Just a tip. Okay, how particular does it have to be? Okay, well, it's got to be fairly particular, okay? It's got to say the place to be searched, the person and things to be seized. What the government's gotten into the habit of doing is trying to cast as wide of a net as possible. Oh yeah, we think that there might actually be, this stolen vehicle there. So we think we have the right to get into the house, the drawers, everything. You're going, what the fuck are you talking about? You're looking for a stolen car. I don't think you can fit a drawer, right? Inside the house. Is there a garage door to get inside the house? No, right? So start tattooing them on that stuff, okay? Because all they're doing is copying and pasting from one warrant to another. Has it been executed properly? Good issues here as well regarding staleness, regarding, as far as when it was executed, regarding how did they execute it, knock and announce, right? And also the scope of the search itself. What are some other matters to consider that we really had to be serious about? All right, standing. Standing is very real, all right? If a person's sitting on the porch at a party, right, were they invited, were they not invited, regardless, do they actually have the right to actually say, hey, you didn't have the right to search his house? No, you lack standing, okay? How did the search and or seizing occur? Well, I'm sorry, who? It limits not just everybody, but just the government actions, government agents, government actors. In other words, it applies to deputy dog, not nosy Nelly, the next door neighbor, okay? And when do we typically raise Fourth Amendment issues? Typically, although it's not a solid, rule of law, it must be raised at this time and this time only. Typically, we're going to raise it in pretrial. And what is our remedy? Obviously, we're looking for exclusion, okay? The other thing I want everybody to know, whenever you have a Fourth Amendment suppression hearing, it's only a hearing, it is not the trial. Meaning what? Your client can testify and they cannot actually use that against him in the trial itself. It's only a hearing, all right? Now, if he gets up on the stand during the trial and testifies differently at the trial than what he said in the hearing, well, that's a different matter, all right? But when I was an appellate defender, what I often saw was people were scared to actually put the client up for a pretrial hearing thinking that they're going to get that evidence in there. It doesn't work that way, okay? Talk to Bob Duddick. He'll let you know about all that stuff. Or Susan or David, everybody, okay? Again, limited government? Yes. Yes, that's right. Okay. Am I sure? Well, it's kind of weird ever since the Patriot Act said, yeah, AT&T and everybody's got to hold on to those records for 5 years so the government can go through them if they want to. So just be careful because they're trying to go under that third-party access and information rule. Or exception, I should say. Now, Fourth Amendment, I'm a firm believer in checklists. Why? There's so much information to filter through. I think they're immensely helpful, okay? Use them or not. It's totally up to you, right? It's your practice. I do encourage them, though. What about exceptions? Yes, there are exceptions to the warrant or to the Fourth Amendment. So many that, yes, even Lady Justice herself would likely get arrested in the United States of America. They include, but are not limited to, what exigent circumstances? Oh, I believe I heard the destruction of evidence when I was at the door. I thought they were flushing items down the toilet. Really? There was not even a toilet in that building. But it doesn't matter. They busted the door down anyway. Avoidance of capture, hot pursuit. Maryland versus Bowie is real. But recently, a bit more curtailed after the United States Supreme Court opinion that came out this year. Person driving for the misdemeanor of DUI, suspected thereof, got all the way to the house, parked, and then the police went on there, arrested, everything like that. And they said, no, hot pursuit does not really count to misdemeanors. Anyway, under Bowie. So anyway, good case law. It's going to be here toward the end of it. I encourage you to read it, okay? Now, what else? Search incident to lawful arrest, which frankly is different than the automobile exception. Most cops don't know this. We do. Use it against them, especially, again, when you're crossing them in your prelim hearings. They don't know that they're getting set up for later on. We play chess. You let them play checkers, all right? Kick their ass where it counts. Next, the plain view exception. Yes, it's there. It's plain view. But hey, wait a second. Oh, I just manipulated and moved it. Can't do that, right? It's plain view. It's only plain view without manipulation by the cops. Inventory search. God, I hate inventory searches, right? I really, really do. What's something we should be really trying to do, though? For every law enforcement agency in your jurisdiction where you practice a lot, whether you do it through FOIA or whatever, get a copy of the procedures, manuals, and requirements. Why? If they're doing inventory searches, which they do every time something's going to get towed, oh, you got a DUS. Yeah, the guy's mom is sitting right next to her. She can drive. No, 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 no. We're going to tow it. Why? Do they really want to tow a car to the impound lot? Fuck no. They want to get inside the car. All right? Let's be real. All right? They're supposed to be following procedures. Where are the procedures? I can't tell you how many times. Usually it's the smaller municipalities. I've sent a FOIA request. I had the chief call me back and laugh. Well, we don't have it. It's like, that's fine, chief. And I'm not here to tangle with the chief at the time. Again, we're playing chess. Chief, I hear you. I just need a letter from you in your office signed by you saying that you guys don't have any policies and procedures manual. That's all. Dun, dun, dun. It's a setup, right? Well, it's not really a setup. It's saying, look, we got them by where it counts. And so when it comes to having that hearing, oh, it's an inventory search, really? And what are your procedures to follow for that? Well, you know, okay, so, and where's this written down for your jurisdiction? Oh, well, right. And you're going to show the court, and you're going to make your record. And then you're going to take that FOIA response letter from the chief of police himself from that municipality, and guess what you're going to do to help Bob Duddick out and everybody up there to file defense? You're going to make it a courts exhibit, and you're going to enter it in there as you're cross-examining the guy, right? It's good. This is what we got to do. We basically have to set them up. What else? Consent. We're going to get into that when it comes to state versus Pearson, because what they call consent through their training and experience, is it really? The answer is no for a lot of these things. And then, of course, abandonment. Who here has had a case where a guy is either rolling down with a bag, has a backpack, walking, riding, whatever it is, cops, oh, and they go, and magically the backpack falls by the wayside, right? That's abandonment. They don't have any reasonable rights to privacy in that. That sucks, there it is. Okay, Terry stop and frisk checklist. All right, who here likes Terry? No, you don't. And this is why. Okay, basically it's a free pat for the cops. But is it supposed to be a free pass for anything? The answer is no, right? What is it? Is there reasonable suspicion supported by articulable facts, for reasonable articulable suspicion of what? Criminal activity to stop them. Is there reasonable belief? This is also, it's two-pronged, right? That the person's armed and dangerous, and can the officer specify with particular facts on which he based his or her belief that the suspect was armed and dangerous? Why? A mere general suspicion or concern for officer safety is not sufficient. Let me say that again. You ready? A mere general concern for officer safety is not sufficient. How many times? Well, pat it on. Why? Officer safety? No. that violates Terry. Why are we just sitting back and taking it? We don't. Set them up, right? And then get ready to turn around and argue, because they're going to say this 6 ways till Sunday. They think this is cool. They think this is their get out of jail free card. Of course I can do this. I'm a cop. I can pat anybody down. No, you can't, right? And then what do? We got the case law with us. We might have like a very brief 1 to 3 page thing, usually bullet pointed out to make it really easy for the judge or the judge's clerk to go, yeah, Stevens, you're right. Here you go. You can't do this, right? Or bare minimum, I'm setting up my record for appeal, right? What else? Continue the checklist. Did he exceed the scope of the proper pat down? I love this one. Why? Because what happens when the cops go ahead and pat down the outer clothing, and they're only supposed to be looking for concealed objects that can be used for, as weapons. And they go, wait a second, this feels like crack to me in my training experience. Fun questions. How often do you smoke crack? Oh, well, oh, okay. And how often do you actually buy large golf ball sized things of crack that it's spiky? Oh, well, I don't do that. Of course you don't. So what is your training and experience? You're telling me at the academy they have you guys feel people up for large balls of crack? No, exactly. So let's talk about this training and experience. He's lying, right? How do you call him a freaking liar? Just correctly so. Highlight the fact that these facts don't support what you just said. Liar. Okay? Not only that, they're not allowed to manipulate it. Thank you, Minnesota versus Dickerson. They can't have a free feel and manipulate the object to determine whether it's contraband or not. Okay? So if you see him do this or hearing this, again, where are we going to pin him down for this stuff where they think it's cool to talk? Prelim. It's your gold mine. Mine it. Do we have a state constitution too? Yes, we do. All right. Use it. Why? Consider it like a double-barrel shotgun. If I have a right that's over here in the United States Constitution, dollars to donuts, there's going to be another one that's parallel to it over here on the state side. And here's why. Because sometimes, wait for it, you can actually get more protection under the state side than you can the federal side. However, as Bob Duddick has repeatedly beat it in all of our heads, if we don't argue it, we didn't preserve it. Right? Argue it. Not only when you argue it, you make the judge give you a ruling on both bases. I had a case before, man, I won't tell the judge's name or even gender, but that judge, I'm not going to get a Christmas card from the judge anytime soon. Why? It was knockdown, it was drag out, it was murder, and I was right, damn it. So, made all these different arguments supporting what we had before us, and when the judge says, denied, Mr. Stevens, okay, judge, I'm not arguing against the judge's ruling. Judge, at this time, for purposes of my notes and for preservation, I need to ask the court for its specific factual and legal basis for each argument proffered. Silence. You guys right now have the exact same response, except the face was a lot more red, okay? According to two of my colleagues, I was about to be thrown in jail. Nonetheless, left the bench, came back next morning, still didn't do what was proper, went back at it, didn't quit. I literally had to argue that single motion for a day and a half until two prosecutors and the judge finally caved. Yeah, it takes that long, and it takes a spine of steel, and if you got it, use it. If you don't, grow one. All right? You can't be rude. You got to be professional. You got to be courteous, and frankly, we are. Okay? We're not bad folks. We're actually doing the one thing that everybody should want to do, which is stand up for the constitutional rights of our clients. This is the United States of America. If I wanted to live in Gulag, Russia, I'd fucking move to Minsk or wherever, okay? Anyway, so what else do we have here in South Carolina? There it is. Article 1, Section 10 has an additional clause regarding privacy. Privacy, if you're on the other side of the pond, right? Yes, and it means something. So it says our own state Supreme Court, thank God, State versus Forrester is a great touchstone case, and it goes there from afterwards. That was 2011, all right? And it reminds us that, yes, there is a relationship between the two constitutions. Think of the United States Constitution as the floor, and states are allowed to go higher. Argue both every single time you have any issue. I don't care if it's a Fourth Amendment case. I don't care if it's a Sixth Amendment type of case. You can look at Article 1, Section 14 when it comes to it. Know your state constitution, all right? I'm a nerd. I literally go over this over the Christmas break. Once a year, I'm going to reread the South Carolina State Constitution, so I know what the fuck I'm talking about, right? Why? When judges realize that you're not here to spin bullshit in front of them. You know your cases, you know your case law, you know your statutes, you know your statutory interpretations, and you know the constitutions, both state and federal, and you're only citing them when they're appropriate and accurate. You know, over time, they're going to listen and they're going to start respecting what you have to say and taking it seriously. All right? It's not easy. It takes time, but it's something, it's a reputation each one of us should start making sure we carve out and earn. So when it comes down to between you and a prosecutor who's got less than 3 years experience, guess who they're going to go with? Well, Mr. Stevens, I hear where you're coming from, and we'll do this, or well, Mr. Prosecutor, this time they might shade it and might try and sound nice to the prosecution like they usually, but honest to God, you build that reputation, you're going to do right, because they also know we know how to make a record. Okay? In other words, yes, the South Carolina Constitution, when it comes to privacy especially, includes, the specific article against unreasonable searches and seizures, and favors an interpretation for a higher level of privacy than the Fourth Amendment. This works. Why? Why is it important? Because the right to privacy against unreasonable invasions of privacy is really, really important. All right. In Orangeburg, we had a rash of cases where they were just using no-knock warrants, just boom, kicking people's doors in at night. You're sitting there going, this is dangerous for fucking everybody, not just the people on who they're kicking the door in, but the cops. Who the hell want to do that? Yeah, this is a great idea. You know why? They got toys, they got guns, they want to use them. Okay, bad idea still. Who else for? The kids inside the same house. Right? It's bad for the population. It's bad for the police. Why are we allowing it to happen? Not on our watch. All right? Stand up and let's make sure we push back hard. And don't forget, like I said, you can't argue one ground at trial and then an alternative ground at appeal. That's why you must argue both. Okay? Anderson County right now. All right. Recent Fourth Amendment cases. I know we're moving through this quickly. I'm not going to read all of these, but here's just a few that came out this year. Okay? Oh, no. This is you got the one up from last year, man. We got the one up from anyway. We got the new one from this year. I sent it to him. I'll make sure that I'll send it to him again. It may have sent him the improper one. That's all right. There's another one that's actually got the new case law from this year. I'll make sure I get another copy of that to you. Okay, Lawrence? Because I think there's roughly 17 new cases that are dead on point, and you're going to want them and you're going to want to read them. Okay, especially some that came from the United States Supreme Court. Okay, this is all from last year. If you want the ones from last year too, they're all really good. Okay, and they're actually more last year than this year. So, all right, we need to talk. State versus Spears. Who read this god-awful case that came out of the South Carolina Supreme Court? And I don't mean that I dislike, yeah, you know what I'm talking about. All right, I love Justice James. I really do. But this opinion is awful. All right, I mean it. So what happens? ICE, they're always friendly. DEA, they're super nice guys. Basically, half of the alphabet is out there looking for two people in particular. One guy named Richardson, another guy named, was it Byers or something like that? Anyway, I forget. Oh, don't forget, there's also two local sheriff's agencies involved, right? They're investigating a tip. What is the tip that requires 2 federal agencies and 2 county sheriff's offices to go, ooh, we're going to stake out a bus station? Well, you know, there's a Chinese bus line. Okay. Why don't they like Chinese bus lines? Well, Chinese bus lines apparently come from New York City and they depart from Chinatown, and they think that they're very loose on their identification requirements and what the people they allow in there. So in other words, what they're saying is trying to gin up reasonable suspicion. God forbid in the United States of America, an American get on a goddamn bus and not tell the government what their itinerary is or give all proper identification. We have the freedom of movement last I fucking checked. And I say that really, really seriously because, goddamn it, a lot of us protected and served this country for years of our lives, and we didn't do it just so people could turn around and just be there at every single moment thinking they're going to bust indoors. This is offensive to everybody, and frankly, if it's not, make it offensive, because it is. All right? Sorry, I'll get up the soapbox. So what do they say? I'm sorry, yeah. They said it was coming from a source city. They said, okay, we have these two black males, and one's named Richardson, the other's Byers or whatever it is. So what about him? What do they see? Did they see these two guys get off of there? No. They saw a black guy named Spears and a woman who also happens to be black get off with 4 pieces of luggage. How dare they carry luggage on a bus, right? That's just wrong in America. So it doesn't match them whatsoever. So what happens? The ICE agent says, well, one of the things we actually do in ICE is we're actually looking for contraband as well. Yes, that's right. Counterfeit items. And since we know that New York City is a source city for contraband and counterfeit items, I was suspicious and I wanted to find out. Bullshit, right? By the way, you're going to tell me that one of the largest cities on planet Earth, at that time in 2012, over 18 million people in the New York City metro area, and you're just going to say this is a source city. We're just going to lay down and take that as defense attorneys? No, screw you. 18 million, actually at the time, 18.3 million people in the greater New York City area have constitutional rights too. Same thing with Atlanta, same thing with Charlotte. They want to use a source city argument. You say, fuck you, show me your stats. All right, I mean it. Stop labeling entire regions as criminal because they have a lot of people or drugs go to those cities. It's wrong, all right? You can't say this is justified. It's like saying, oh, well, it's a rental car. Clearly, that's suspicious. No, they're taking innocent aspects of society and trying to make it. The answer is no, all right? And it takes us to stand up against it. So what do they do when they actually had these people didn't match the names or descriptions or anything thereof? They say, oh, well, they look suspicious. Why? They kept on looking back at us. Oh, you mean the only people that were there staring at everybody else with fucking guns out like this and badges staring at them? Yeah, I'd be pretty suspicious of them too, right? So they said, well, they were walking away from us. Well, no shit. They're trying to go to their destination. So what do? Well, we walked up behind them briskly, right? Excuse me, sir, excuse me, right? That's what they're doing. Who wouldn't freak out about that? What the hell is this dude, plain clothes, mind you, with a gun, 2 of them coming up right behind him fast? Yeah, that's alarming. Let's flip the script. If 2 people came up behind them, especially, God forbid, if they're African American or other persons of color like that, and they're 2 cops, they draw down on their asses, right? Why is it okay for them to do that to our clients when they would never put up with that themselves? Well, my training and experience. Bullshit, right? And they stuck out because they're paying excess amount of attention, all that good stuff, right? So I'm sorry, not 2, but 3. 3 cops, plain clothes, just showing, chase them down by walking briskly, stop and just say, hey, would you please speak with us? No kidding. If you actually read the opinion, and I'm asking each and every one of you, you have a homework assignment over this Thanksgiving break, read State versus Spears, and pay close attention to the set by the only 2 people on the bench that are people of color, our Chief Justice as well as Judge Gethers, okay? We're going to get into that too in just a second. What happens next? Oh, the trial judge, I like the trial judge a lot too, but he said, no, I'm going to turn around and let this in. What do? Because they turn around and they're asking questions. What were the questions they were asking? Where are you coming from? Where did you drive from? Well, that's the source city. Well, we're actually looking for these people for, trafficking, drugs or other illegals. Hey, and he was what? They felt he had his hands in his pocket. And hey, don't put your hands in your pocket. By the way, they tried to claim that this was a consensual encounter. They acknowledged there was no reasonable articulable suspicion, but don't put your hands in your pocket. Don't do that. Keep them where I can see them. Wait a second. Remember what Terry requires? If there's no RAS, and what else? If they're not really suspected of carrying firearms, general officer safety is not sufficient. This violates even Terry. So they frisk him. I felt a golf ball size, thing in his waistband. And I saw her beforehand. I saw her pass something to him, and his hands didn't go higher than his waistband. Well, how the fuck did he see in front of him if he come up from behind? Right? And I knew from my training and experience, subjective, by the way, think about that. Anytime a cop says, based on my training and experience, you're talking about a subjective perspective, right? Okay. I want you to remember that when you see how the majority rationalizes its response when it comes to totality of the circumstances. Sorry. What are we talking about? What happened? We failed Mr. Spears. All right? We, the defense, did. How? And it pains me to say this. I mean, I'm getting painful chills right now thinking about this. How did we fail him? We failed to make a proper record about this. They won at Court of Appeals. Hey, Judge Contreras totally got it right. So she did. She's awesome. Right? How did we fail, though? We didn't make a record for the issue. Spears, the defense, never argued whether race was a factor in whether he would have felt free to leave. The argument was a reasonable person in his shoes would not have felt free to go. Therefore, under Mendenhall, when we touched on before, that's a seizure. And they're right. So what did our Supreme Court do? They turned it on its head. They said, well, reasonable personal standard, race is kind of irrelevant anyway. You went, oh, is it really? So under the totality of circumstances, they're cool with using the cop's subjective views and experience, but not the defendant? Time out. I think it's wrong. And so does the minority. But the big problem here is nobody even pushed it. Examine United States Supreme Court cases on the race and consent. Question of whether the defendant's consent to accompanying agents was in fact voluntary or was a product of coercion, expressed or implied, is to be determined by the totality of the circumstances. So it's not just a reasonable person standard. I'm hearing totality of the circumstances. If the cops can do it, so can we. That's what I'm hearing. That's an invitation. He didn't consider the race because it wasn't raised. Now, the part you are all going to love about the Spears case is the dissent. Chief Justice Beatty gave us an invitation in his dissent, and he is spot on. What does he say? A true consideration of the totality of the circumstances cannot ignore how an individual's personal characteristics and accompanying experiences impact whether he or she would have felt free to terminate the encounter with law enforcement. In other words, he's right. How a person was raised, what they've actually gone through is going to determine whether or not they felt free to get away from a cop. Right? Yes. Yes, it is, Stevens. Okay, that's good. What else? He went through all the different aspects of it when it comes to scholarly aspects of it. By the way, I encourage you, don't just read the opinion, follow the links, get those other aspects of the scholarly aspects, and include those quotes and bits from other people with half the alphabet in front of the name, the good alphabet, not ICE and DEA. I mean, PhDs, all those other things, right? Those count in a court. At least they do in your briefs, okay? Use it. It's there for us. And then he says, look, in my opinion, the seizure analysis should consider whether a reasonable black person was felt free to leave the encounter with the police. Yes, he's right. At the very least, courts should consider the person's race and other personal characteristics. This is not just about skin color. This is about the characteristics of the individual in the situation, right? We can consider it for cops. Why can't we consider it for the defendant? What's good for the goose is good for the gander, especially if we're talking about totality of the circumstances. Okay. And again, for most, the totality of circumstances does not include consideration of the reasonable behavior response of African Americans when confronted with certain stimuli. Thus, the regrettable conclusion is that the question of what is reasonable is viewed solely from the perspective of Americans who are white. By the way, this whole notion of, oh, well, it's the majority perspective, so they're going to try and go into percentages. The percentages of what is going to constitute the population of America is about to drastically change by the time we hit 2050, right? Methinks the standard might change by then, right? Where they're going to say, well, maybe we really should consider this, but since, I know, the minority is going to change. Long story short, what should we have done? What should we have done in the Spears case? How do we make this record? I mean, these are just my suggestions. All right, yes, we got our client testimony. Got to have that. Do not be scared in a suppression hearing to put your client on the fun-loving stand, okay? 2, eyewitness testimony. How many other people were there at that bus stop? A lot of people, okay? It might be hard to actually track down who all was there. Do what you can, as early as you can. You heard the conversation with my boss, Mr. Leindecker, regarding discovery, regarding videos. The thing about videos is this, you got to get it quick, because even with Walmart, you only got about a 30-day shelf life before it's overwritten. I mean it. Yeah. The sooner you get it, the better you can, and you got to act fast. Okay? And they'll say, oh, well, it's too much information. It's like a terabyte. It's like, oh, it's okay. We'll send our own hard drive with at least a terabyte, maybe even 3. Okay? I'm willing to turn around and spend the coin from our office just for that piece of hardware so we can make sure we get the information that's going to help our clients so we can make sure our record is proper for people like Mr. Spears. What else? Sociologist testimony regarding statistics, psychologist testimony regarding how folks in our client's shoes typically would respond given that situation. I have a good friend of mine who is a doctor, PhD, as a psychologist. Frankly, he does a lot of good things, right? I think now he's working for the government over at SCDC, all right, trying to fix a big mess they have there, right? I've got information from him on where we can actually reach out and get experts that would be able to help us out when it comes to this type of issue, okay? What else? Secondary sources, psychological and sociological published works. Put these in your motions, use it in your direct examination of expert witnesses, and then turn around and fashion some questions for the cops. This is what we have to do, right? Bob, David, Susan, none of them can do anything for our clients on appeal unless we lay the foundation. It is up to us. This dissent is our invitation. It's a wake-up call. It's a kick in the ass. Call it what you will. It's up to us to do the legwork, to do the extra work. And I got it. We're all overloaded with crazy amounts of cases. But you know what? Mr. Spears needs a voice. Mr. Spears needs a champion. Mr. Spears needs us to lay that foundation for him, to go up there and to get that expert. Not in every single case, but in the cases where we know it's actually important and pertinent to what we're looking at. Take that ex parte, fulfill the ex parte motion. Get that motion for the expert. If you talk to him, find out what it's going to cost to actually talk to him about, hey, can you at least look this over? What's that going to be? We'll get the game started when it comes to that. If we need to actually talk about testimony later on, fine, we'll talk about that fee as well. The point is, get the ball rolling in cases where we know it matters. Our clients, like Eric Spears, rely on it. And we are the voice of the voiceless. Thank you.